Good morning to everyone who's joined us. We are here today to talk about the Section 45 Statutory Defence. If you are able to let me know that you can hear me on the chat. Yep, great. Okay, some of you saying you can hear me. Okay, there have been technical issues on our trial last week, so I've been trying to work on that, and I did find this link from their website, so I'm going to post that. Some people struggle to hear, and some people struggle to see the slides. So if you have a look at this article, then hopefully that will assist. What I have heard in the past is that there have been issues and they've been solved by either checking the web browser, so try Chrome instead of another one. I've also heard that sometimes if it wasn't working on laptops, then you can try it on phones instead. And I've also heard that there's a refresh button at the top right of the screen. So if you're having any technical issues, then please try them first. We're going to get going soon. We've got about half the people who have registered have joined. If you've joined any of these at all before, then you know the drill by now. If you're able just to put your job title on the I've seen some people have already knew what I was going to say and I've put it on. If you can put your job title in the chat, it gives an idea about who's joining us, and then it makes it easier for me to know who is here. I've just saw a question regarding the recording for the Vietnam one I did on Thursday. Yeah, for some reason, when I click publish, like I did for the first one, it just hasn't worked yet. So again, I've been speaking to the website about technical support there. But yeah, I'm doing my best. And I think the website emails you automatically if you registered, and then once the recording is there, if you missed it, and it should, I think the email actually looks like it's from me and not someone else. Okay, so let's see what we have here. Okay, so we've got partnership, we've got youth justice, child exploitation coordinator, social worker. Great. All right then. So yeah, thank you very much for joining us today on this Monday morning. I hope you had a good weekend, as much as you can in this situation. Just to introduce myself, my name is Phil Spencer. I'm the Training and Practice Officer at ECPAT UK. As all of my face-to-face training has been postponed for several months, what we've tried to do is just to keep things going with these short introductory webinars on certain issues that we train on. My professional background is I'm a social worker, worked both in child protection and in youth justice, as well as working in trafficking organisations abroad before I came to do this. Something which is missing in this kind of training compared to when I do face-to-face training is that it's not very interactive at all. So apologies for that. I'm trying to work out how to make it more interactive. I have worked out how to add a poll, which some people have found, and it's basically just about if you've ever had experiences of a Section 45 statutory defence. It'll be really useful to get a poll on that, but then you can also put in the chat what experiences you've had, whether that's been positive or negative, so everyone can see that. Okay, as I'm talking, I'm going to try and not look at the chat. The reason why is because I get distracted by when I'm reading that and I totally lose my place in the presentation. But I may look from time to time. So if you're asking me questions in there, I'm not being rude and not answering them. Somewhere else on your screen, on my screen, it's towards the bottom underneath the slides, is questions. So feel free to answer a question, and then at the end, I will do my best to answer those questions. Okay, so I'll definitely see the questions if you put it in there, but maybe not if it's been in the chat. Okay, so can everyone see the slides? I'm hoping that you can. Yeah. No. Okay. If you click the refresh button, then I'm hoping that you will be able to see some slides. I might come on the screen in a second. The reason why is because I'm trying to sort of refresh the slides. So can people see the slides now? Yeah. Okay. Everyone now is saying yes. Okay, so I'm going to start. If you can't see the slides, unfortunately, I can't see your screen, so I don't exactly know where they are. But I will also be sending slides around. I'd try the refresh button, or again, I'm going to publish a link to the website's article on if that you're having any technical issues. Okay, so I'm sorry that not everyone can see them, but because the majority can see them, I'm going to continue. Okay, so ECPAT UK, we're a small charity. We focus on issues of child trafficking, modern slavery, and exploitation. We have a research arm, and for the research, we produce various different amounts as much as possible. We would like to produce more research, but as everything, it's based on funding. And last week we did. I presented on our research into trafficking from Vietnam to the UK. Tomorrow, I'm going to be presenting on our research of child victims of trafficking going missing from care. So I am just going to quickly post the registration link for that, tomorrow's webinar. But yeah, we have a research arm. Apart from that, we do campaigning. So we campaign around legislative issues around child trafficking. I run the training program. Mostly we train social workers and other children's services staff, but other frontline professionals, care workers, police officers, NHS staff, and many others. As well as that, we have a youth program. So based in London, we have a girls group and a boys group, and we provide as much support as possible really for them. So if you are a practitioner in London and you work with potential child victims of trafficking, you can refer young people to us between the ages of 15 and 23. If you want more information, you can always get in contact with me about that. Okay, so just before we go on to the Section 45 statutory defence, this really fits into everything about child criminal exploitation and forced criminality. We do have an entire training day on this, so I definitely cannot go into it in this 45-minute webinar. However, this is just a very specific part of that, but I have just included some common forms of child criminal exploitation that we do see. We see cannabis cultivation, as well as other production of drugs like crack cocaine and methamphetamine, theft, pickpocketing, forced begging. That links into fraudulent ID documents or stealing of ID documents and recycling them. We also see drug offences, drug supply offences and possession of offensive weapons. We also see young people being forced to commit sexual offences as well. Again, I'm not going to go into this today, but it is something that we do see and something to consider. And then we see fraud and money laundering. And then outside of the cities, generally, we see metal theft inside the cities. Practitioners are often quite surprised by that. Okay, so just introducing the Section 45 Statutory Defence. It's based on the principles of non-prosecution of children who have been exploited. Okay, those international principles have been around for a long time. They're in the UN Convention on Human Rights, the UN Convention on the Rights of the Child. In the EU, we've had the European Convention and the EU Directive for Trafficked Children. So for a long time, this idea of non-prosecution has been there, and it's been there in international law for a long time. But it was finally put into UK legislation in the Modern Slavery Act 2015. And again, it's called Section 45 because in the Modern Slavery Act, that's the section which relates to the statutory defence. Okay. So, to put it simply, the Section 45 of the Modern Slavery Act provides a statutory defence for child victims of trafficking who commit criminal offences through their actions whilst being trafficked and exploited. So we're going to just go on to the exact legal definition in the next slide, but this is who it is for. If there is a child who has been exploited and because of that exploitation, they have committed an offence, the Section 45 of the Modern Slavery Act provides a statutory defence, basically under the common law of duress, which a child can claim in the light of any sort of prosecution. Now, in practice, to have the Section 45 statutory defence claimed, it's really dependent on a national referral mechanism being done for that young person. So I've never seen in court or heard of any occasions where the Section 45 statutory defence has been claimed and accepted if there has not been a national referral mechanism referral for that young person. So the two are quite closely linked. Because of that, I am just going to mention last week's webinar, which I did, which was just an introductory webinar really into the national referral mechanism. So if that's useful to you, I've put that link in the open chat, and that one, the recording is working, so you can go back using that link and you can just listen to the recording of that. And this is something else that I said in the NRM webinar, and I'll definitely say it here because it's just really important for non-prosecution, really, is that early NRM referrals are important for cases of criminal exploitation. So if a young person that you're working with, you are worried about criminal exploitation, please do not wait for them to get arrested or for them to get charged with an offence before you put in an NRM referral. It just helps frame what is happening to that young person for a professional who has never met them before. So a police officer may be arresting this young person and they may be interviewing them for an offence. If they can already see that an NRM referral has happened, then it just puts in their mind that possibility that this is a child exploitation case instead of treating them as a perpetrator of an offence. Similarly, for a young person's first appearance in court, this really, the Section 45 statutory defence really needs to be raised at the first appearance, ideally before a young person puts in a plea. The reason why is because once a young person pleads either guilty or not guilty, it's very hard for the prosecution to withdraw charges against a young person, and it's very hard for them to get rid of them. So I would definitely say, please do NRM referrals early if you are worried about a young person, and therefore that gives us an opportunity for the Section 45 statutory defence to be claimed for a young person. As soon as we're a little bit late in those NRM referrals and claiming statutory defence, a young person may have already been convicted of an offence, and then they would have to go through the appeal process, which very rarely ever happens, and it would take years, even if they did, for their conviction to be quashed or even heard. Okay, so again, just emphasis on early response from professionals. So what is on your screen now is the legal test for the Section 45 statutory defence, and it is: would any reasonable person in the same situation who has the person's relevant characteristics would have no realistic alternative to doing that act? So I'll let you think about that and read it again. It essentially means, would a person in their same situation who is like that person also do that? Okay, so a reasonable person, this is a very wide term and a very subjective term. So that is always problematic in terms of legal arguments. In the same situation, who has the same person's relevant characteristics. So what that is really getting at is a young person's age, their maybe background, their family characteristics, maybe it's even thinking about demographic factors or ethnicity. I'm not sure, but essentially means a child who is like that child, okay? And who would have no realistic alternative to doing that act. So again, what that's getting at is looking at compulsion, okay? Is that young person forced into that? And would any young person in that situation do the same thing? Okay, so to me, that seems like a good legal test. Some terms in there are vague, but it seems like it's not a high bar to reach for young people. It seems quite possible that that is going to get the correct young people are going to meet that test. Okay, however, because these terms are quite broad and subjective, these are open to interpretation, and therefore it really can depend on the prosecutor. So if you're looking at a case of drug supply and a young person who has been charged with possession with intent to supply, and they may be what we think of as county lines exploitation, and they've been sucked into that. I've heard prosecutors say, well, they did have an alternative. They could have called the police, or they could have told their mum. And that was as simple as the reasoning for that prosecutor to say that they don't meet the legal test. Okay. For me, that is probably the wrong interpretation because it's a realistic alternative and what would have happened with that young person if they would have called the police. So that is the legal test. If you are thinking about using the Section 45 statutory defence, then that is what you need to be asking yourself: is can that young person sort of meet the bar which is set there? Okay, I've also put in this is just in a little bit more detail. And the reason why I've added this in is because I knew that there were going to be youth justice practitioners involved in this webinar. And if I'm thinking back to when I was a court officer working in youth offending, it was often us that was making the we were raising the point of the Section 45 statutory defence and not defence solicitors. And this is what we were trying to speak to the CPS and the prosecutor and trying to raise these issues. Now, since then, I found this is what the prosecution needs to ask themselves, whether they're going to continue with non-prosecution. And the reason why I've put this on the slides is because for me, this is quite useful, is that these are the tests that the prosecutor will have to ask themselves, but we can help them and we can answer these questions for them. And then if we are answering these questions for them, then it's going to put the prosecutor in a situation where they have to sort of disagree and give reasons for their disagreeing with us, instead of us maybe being on the back foot. Okay, so this is what they'll be asking. They'll be asking, is there reason to believe that a person is a victim of trafficking or slavery? So again, you can put these in formal letters to the court. We've done that before as a youth offending service. If the police maybe haven't accepted that this young person is being criminally exploited, then we would also write our submissions to the court. And we clearly say this has been a multi-agency discussion. This is an occasion where us and the police are in disagreement, and this is why we feel like the Section 45 statutory defence applies. Is there clear evidence of duress and a credible common law defence of duress? So again, this is a little bit contradictory, because for young people, you don't need to prove coercion or control if they've been exploited or trafficked. But under the Section 45 statutory defence, there does need to be evidence of there being some sort of coercion, control, or duress for a young person. So again, that's almost raising the bar compared to a definition of a young person who's been trafficked. Next is there clear evidence of a statutory defence under Section 45? So again, that would be really just going into the legislation. I'm not sure if I have put a link in my documents that I'll send and I'll put up to that piece of legislation, but it's easy enough to search, and then they just need to look at whether the young person is eligible. And then finally, is it in the public interest to prosecute? I'm going to talk about Schedule 4 in a little bit, which is a problem with the Section 45 statutory defence, but it must also be considered whether to prosecute or whether to withdraw prosecution, even if the young person is charged with a Schedule 4 offence. So it's not absolute, the exceptions of Schedule 4. Okay. So I will send around the slides after. If you are someone who's working with young people in youth court or even Crown Court, I would just have this in my mind, is that if I'm trying to persuade people to that this young person is being criminally exploited and therefore they should not be prosecuted, then these are the questions that I would be looking to answer. And this is what you would need to provide evidence for. Okay, so far I've sort of described the parameters of Section 45. It's quite good. I think it's good that we have it, and it has a big potential to be used in the right way, and a lot of young people to be supported through it. However, there are some issues with it. So I mentioned earlier that the Section 45 statutory defence and NRMs are quite linked. In my experience, courts will wait for an outcome of an NRM to decide whether to continue prosecution or not. Some courts I've seen will wait just for a reasonable grounds decision, which means they're essentially investigating whether there has been trafficking or modern slavery. But most courts where I've seen it is that they want to wait for a conclusive grounds decision to be made before they decide whether the prosecution will continue or not. However, courts are not bound to the rulings of NRMs. So I was aware of a case which is probably now finished in the Crown Courts of a young person who received a positive conclusive grounds NRM decision, but the prosecutor continued with with the prosecution, regardless of the defence claiming the statutory defence, Section 45 statutory defence. That is because of the burden of proof. If you think back to the NRM webinar, the burden of proof for conclusive grounds is more likely than not. So it means if there is more than a 50% chance that this is a young person who has been trafficked, then they will receive a positive conclusive grounds decision. But as we know, in a criminal court, the burden of proof is beyond reasonable doubt. So because the evidential burden on criminal courts is so much higher than it is for NRM decisions, that is why courts are not bound to NRM decisions. Okay, so they have to take them into account, but they are not bound by them. And this, if you're interested in the case law, is there below, R versus Eleanor's. So that was where it was decided. Okay. The other potentially problematic part of Section 45 statutory defence is that this, which has come up in the CPS guidance, I'm just going to post a link to it, but the CPS guidance is a live document, so it's always being updated. I can't ever remember seeing this phrase in the guidance for human trafficking and modern slavery until recently. And from when I was trained by the CPS and they directly gave their guidance down to us on cases of criminal exploitation, that must have been 2016 or 2017. This appears to be different, and this appears to be more strict, really. But this is what it says. It says, if a person, by joining an illegal organization or a similar group of people with criminal objectives and coercive methods, they voluntarily expose and submits himself to legal compulsion. So it sounds quite worrying to me that this is in there, but it essentially is saying if a young person is voluntarily sort of surrendering themselves to criminal coercion, then this is something that they've done voluntarily, and therefore the Section 45 statutory defence does not apply to him. I think it's really, really problematic, and I think it's inconsistent with the Modern Slavery Act and Section 45 laws. I think it's incompatible with definitions of child exploitation and human trafficking. So just to be aware that this is in there, and it's something which I'm not sure whether it is being argued a lot, but to me it just sounds like this phrase in the CPS guidance gives prosecutors a lot of scope to continue with prosecutions with criminal exploitation, even when under Section 45 we would normally think that they would have it. Something also to note, which I have been unprepared about, but we do have youth justice practitioners here. The Ministry of Justice has released statutory guidance for youth offending teams dealing with county lines. They released it last November or something. So maybe towards the end, I'll try and get that link and publish it. But it's, it'll be useful for you to have a look at that. And it does kind of show the direction of travel. And this phrase is also in there about if they voluntarily submit themselves or join an illegal organization, then the Section 45 defence doesn't necessarily apply to them. So please note that down if you are a youth justice practitioner, as it may be relevant to you. Okay. So next, I'll just mention the Schedule 4. So I've already mentioned it. Basically, there's a little small print in the legislation that says Schedule 4 offences are not included. Now, it's something that we wouldn't normally notice or normally look at, but there are hundreds of offences which are excluded from the Section 45 statutory defence, which means that if a young person has been criminally exploited and then is subsequently charged with that offence, they cannot claim the statutory defence. So some of them which I think are particularly problematic are on the screen now. I am aware, as I'm sure many of you are, of young people being criminally exploited and forced to commit robberies. Similarly, with possession of firearms, I think that is something that is very, very likely or possible to happen to young people. And then again, you look at these modern slavery offences. Something that we go into detail more in our training is that as a way of survival, young people often end up recruiting other young people to be exploited. And it's something that in programs such as Three Girls that you see it's a way of survival essentially. And because of that, it's really problematic that a young person may not be eligible for statutory defence, or possibly if it's extended further into thinking about NRM outcomes, is that a young person isn't eligible if they themselves have potentially been involved in exploiting other children. So it is complicated, but it can be, I think it can be quite problematic. And then in a similar way, sexual offences would be included in there. So I am aware of cases where young people have been investigated, young girls have been investigated for their involvement in recruiting other young girls to be sexually exploited. So if we're ever in a situation where a young person is charged with those offences, she also cannot claim the statutory defence. It's something that you saw in the Three Girls last episode, where the eldest girl was actually on the indictment of the men. So it is problematic. I've just seen that someone's mentioned that they've got a case like it at the moment. So it's sad that it does happen, but it is a real problem, really. Also, I'm not going to go into much detail with it, but if we're thinking about boys who may be pulled through, sort of pushed into committing their own sexual offences because of their involvement in gangs or criminal exploitation. So it is certainly possible, and it's complicated and it's an issue with Schedule 4. However, as I mentioned, and I put on the slide around the prosecution tests, it is still possible for a prosecution to not go ahead if it's not in the public interest. So we can still make the claim that prosecution should be withdrawn in these situations. So there is still a small window for us to be able to use this Section 45 defence. Okay, so just some challenges of the Section 45 defence. There is a lack of awareness of it, and there is a lack of understanding about the non-prosecution provisions. Now, this is nothing to do about professional competence or anything, because the legislation itself is contradictory. So if you're working with a young person who has committed offences under the 1998 Crime and Disorder Act, they are criminally responsible for their offences. But that's contradictory to the Modern Slavery Act, which says that they are not responsible for their offences if they have happened through the process of exploitation. So there's contradictory legislation on this, and our sort of main legislative context does not necessarily recognise non-prosecution, and instead it emphasizes criminal responsibility of a young person. So it isn't practitioners' fault that there is a lack of awareness around it. Next is that it's inconsistently used. So first of all, across different offences, what I'm sure a lot of you may be seeing is that for potential county line drug offences, it is being used quite widely, and courts are used to this. But my question is why are we not using it for young girls or boys from Eastern European countries who have been charged with theft offences? Because just as much as people may be criminally exploited for supplying drugs, people are criminally exploited for begging and pickpocketing and committing thefts. But I've never seen a Section 45 defence used for theft offences at all. And therefore, I just think that just shows a massive inconsistency there. It's also inconsistent in how local authorities use it and their guidelines. So you see in some local authorities it is used very readily, and in other local authorities it isn't used at all, or the threshold is quite high. And that again may not be necessarily solely due to the local authorities, but actually it could be a lot to do with the courts. Different courts in different locations have a very different understanding or relationship with the Section 45 defence. So again, that's where we see a change. I've just seen that someone is saying that they use this defence for theft regularly. Excellent, well done. I'm very happy that that's happening. It's something that I'm probably ashamed to say that in my old practice before, I wasn't. That was a blind spot, really, is that we were happy to use it as Section 45 defences, but we very rarely used or claimed the Section 45 defence for theft offences. Again, this might be something that you want to share in your in the open chat, but courts use this differently. It's interesting. It's always interesting for me to hear what the different local courts' approaches are to the Section 45 defence. By the time that I stopped being a court officer, I know that our court seemed quite fatigued with Section 45 defences. We were often educating solicitors around this, and then we found that solicitors were sort of invoking it at every occasion. And plenty of those cases may have been exploitation, but they weren't quite justifying the defence very well. And what it meant is that we felt that there was a backlash from the court of anyone using it, and it wasn't being properly it wasn't being considered, really. So that's something I'm seeing. It would be really interesting to hear in different areas how different courts are using the Section 45 defence or not using it. The next issue is that it's causing delays in youth courts. So as I mentioned before, it's really, we want to raise this as a defence prior to a young person putting in their pleas. But that causes their own issues with young people being referred to the NRM and then having to wait 6 or 8 months for an NRM outcome before they can even put in their plea for an offence. So that is really problematic, particularly with the emphasis on getting outcomes in the criminal justice system quite quickly. So it does cause a problem. It causes a problem when a young person is on bail for that long. It causes a problem in the way that in many of those occasions when we finally did get an outcome is that that was a negative NRM decision, and therefore that young person put in their pleas and was essentially been on an order for his offence for 6 to 8 months longer. So it is problematic. The other problem with it is that the courts started to get quite fed up with this, and then they started putting a lot of pressure on the people who decide the outcomes. So what's called the single competent authority are the ones that issue these positive or negative NRM decisions, and there was a lot of pressure put on them. And what it meant was that cases which were in the youth courts for criminal exploitation, their cases were fast-tracked within the single competent authority. But ECPAT UK is on the board of what's called the multi-agency assurance panels, which are these panels which review negative decisions made by the single competent authority. And what it looks like is that when these cases have been fast tracked, it's actually more likely to come out as a negative decision for that young person, because the single competent authority isn't having the time to properly investigate whether this is a victim of trafficking. And if there's a lack of evidence, then they give it a negative, the NRM referral, they give it as a negative conclusive grounds decision. So it's causing problems in the delays, but the solution of trying to fast track these cases is causing further problems for young people. And then increasingly what we're hearing is a lot of people who are working for state agencies are starting to talk about the Section 45 statutory defence a lot, and they're not talking about it in good ways. So at the moment, we are slightly worried that the Section 45 statutory defence might be taken away, or it might be watered down. And this is after some cases of perceived misuse of this. How I've sort of followed the narrative is that they've seen that as they've rolled out and there's more awareness of the statutory defence, so many young people are being identified as exploited, and they just feel like too many young people are not being prosecuted, and they just can't deal with the number of young people who are being considered exploited and therefore using the statutory defence. That's what it sounds like to me. There are cases where they're quoting that it has been misused, and like any sort of protection provision, there is scope for it to be misused. Sometimes it may be misused, but our concern at the moment is that it's going to be stripped, and that's something that we would be very worried to have, because at the moment it's quite an important safeguard for young people. Just so you are aware, the Independent Anti-Slavery Commissioner over the last couple of months has been collecting evidence for the Section 45 statutory defence. Unfortunately, she has now closed the invitation for evidence. I don't know how well this was known, but she was trying to get as many people and frontline practitioners as possible to give their views and their experiences of the defence. So she's currently looking into that, and I'm not sure when she will produce a report on the Section 45 defence, whether it will be later on in the year or maybe start of next year. I'm not sure. But just to be aware that the IASC, the Independent Anti-Slavery Commissioner, is looking into it at the moment. So it will be interesting what she comes out with. Just going to have a quick look on the chat. Okay, great. So some people are saying that they have fed into the IASC's report. So that's basically everything I've got on the Section 45 just for today. So I'm going to give you a chance to ask some questions. While you ask some questions, I'm just going to go through another couple of things so you can listen in the background. Firstly, this is just a tiny little piece of our training courses for professionals. The ones on the screen at the moment are our main courses, but we do have other courses. So, for example, we have just created a new course for advanced training in child trafficking, modern slavery and exploitation, which is a 3-day course. We also, our most popular courses at the moment are our child criminal exploitation and trafficking course, as well as our safe accommodation and missing from care course, which both of them are really good courses, and they have been of particular interest at the moment to practitioners. So if you are interested, then please get in contact with me. Obviously, face-to-face training isn't happening right now, but if your organisation is interested, then there's no harm in us speaking to try and work out what and when you would like in terms of training. If you'd like to, you can sign up to our e-news. That's our website there. We have several campaigns. Our main one is about supporting the ICTIG rollout, the Independent Child Trafficking Guardians. This again was in the Modern Slavery Act 2015. It's a right to a guardian for child victims of trafficking. Even though it's been in law for 5 years, still only 1/3 of the country is covered by an ICTIG service. So if you want to sign our petitions, there's one around that, and there's one around stable futures for child victims of trafficking.